The current Michigan Supreme Court is constituted by way of a provision in the Michigan Constitution, and it has 7 members, and those members serve 8-year terms. And there are 2 seats of the court contested every 2 years. The candidates for the Michigan Supreme Court are selected at the state party conventions, at the Republican Convention and the Democratic Convention. Once the candidates are nominated, they are then placed on the ballot. If you look at the ballot, you won't see which candidates have been nominated by which party, because they are contained on the nonpartisan portion of the ballot. What you will see on the ballot is whether or not the person standing for election is an incumbent. If they are, it will say under their name, Justice of the Michigan Supreme Court. They're paid $165,000 a year, and judges may not seek re-election after they reach the age of 70. The current Chief Justice of the Michigan Supreme Court is Chief Justice Robert Young. He joined the Michigan Supreme Court, when he was appointed to the court in 1999 by then Governor John Engler. He reached the Supreme Court after first having been appointed to the Michigan Court of Appeals, also by John Engler. And he came to the Michigan Court of Appeals from his prior job as the general counsel for AAA Insurance Company. Justice Young is joined on the court by Justice Stephen Markman, who has served on the Michigan Supreme Court since 1999. He too began his judicial career with an appointment to the Michigan Court of Appeals by then Governor John Engler, and then was again appointed to the Michigan Supreme Court by John Engler in 1999. Judge Markman's up for re-election this fall. His current term expires, so he will be on the ballot this fall. Justice Mary Beth Kelly, also a Republican, was appointed to her initial judicial post, which was at the Wayne County Circuit Court by none other than former Governor John Engler in 1999. She was then elected to the Michigan Supreme Court in 2010, and her term will not expire until 2019. Justice Brian Zara is the newest member of the Michigan Supreme Court. He was appointed to his current position by Governor Rick Snyder in 2011 to fill the term of then Justice Maura Corrigan, who left the court to join the Snyder administration. Judge Zara, prior to joining the court in 2011, had served on the Michigan Court of Appeals, where it will come as no surprise to you that he had been appointed by John Engler in 1998 after serving as a judge of the Wayne County Circuit Court, where he had also been appointed by Governor Engler in 1994. Justice Michael Kavanaugh is a Democrat, serves on the Michigan Supreme Court, and has served there since 1992. He was first elected to the Michigan Court of Appeals in 1975, and then again to the Michigan Supreme Court in 1982. His current term expires in 2015, at which time he will be age limited and unable to run again. Justice Diane Hathaway, also a Democrat, serves on the Michigan Supreme Court, having won election to the court in 2008, defeating then Chief Justice Clifford Taylor, and her term will expire in 2017. Justice Marilyn Kelly has been serving on the Michigan Supreme Court since 1996, when she was first elected to that post. She had also been elected to the Michigan Court of Appeals in 1988. Prior to that, she had been the president of the Michigan Board of Education, and prior to that, she had been a lawyer in private practice. Justice Kelly is age limited. She may not seek re-election this fall, and as such, her seat on the Supreme Court is now open. Whenever I talk about the justices of the Supreme Court, I have to stop for a moment just to acknowledge Justice Kelly, who has, during her tenure on the court, consistently written opinions which are highly regarded by lawyers around the state. If you ever wonder whether the work you do to place justices on the Supreme Court is worthwhile, you'd only have to look at the opinions that are written by Justice Kelly to know that in fact that it is. because she has consistently represented a point of view of integrity, of fairness, of equality, and you would be proud of her, and you would be proud of the fact that she represents you on the Michigan Supreme Court, because she serves as a judge in the highest respect. The Supreme Court is elected much like other candidates to public office, and then they go out and raise money and run campaigns. In fact, during the last election cycle, Michigan's campaign for the High Court was the most expensive in the history of the United States. Although we don't know the precise amount that was spent, because much of the money comes from outside sources and it's not reported, estimates are that there was approximately $11.5 million spent on the last campaign. That's more than twice the amount spent on the second most expensive race in the country, which was in Pennsylvania, where they spent just under $5 million. Of the $11.5 million that were spent in the last election cycle, only 20% of that was raised by actual candidates. 80% was spent by outside groups, and a majority of those funds are unreported. The Michigan Chamber of Commerce, for example, spent $5.4 million, which they gave to a group called the Republican Governors Association, which then turned and injected those funds straight into the Michigan Supreme Court race on behalf of Republican candidates. The Republican Governors Association is typical of the shell organizations that are used to spend money in court races throughout the country, and particularly in Michigan. The Republican Governors Association collects and spends significant funds on what they call issue advertising and direct advertising. In 2010, the RGA, Republican Governors Association, received nearly $2 million from the DeVos family. It received more than $8 million from non-Michigan residents, including nearly $1 million from David Koch of the Koch Foundation and Koch Industries, which many of you, I'm sure, will recognize as a large mining and extractive industry, and one of the corporations with the longest criminal record in the history of the United States. When it comes to the environment, we in the state of Michigan obviously have a great deal to enjoy and then a great deal to protect. And because of that, we have our own Environmental Protection Act, the Michigan Environmental Protection Act, which was passed by the legislature, and under which, according to the Act, the Attorney General or any person may bring an action in court to stop any conduct that's harmful to the environment. And the Supreme Court looked at the Environmental Protection Act in a case called Michigan Citizens for Water Conservation versus Nestle. In the Nestle case, Nestle, who bottles and sells water for a profit, wanted to put in a large well in Michigan and pump water to be bottled and sold. The folks who lived near Nestle's large well indicated that it was draining their aquifer, and the water in the creeks were going down. And so they formed an organization called Michigan Citizens for Water Conservation and filed suit. That suit worked its way to the Michigan Supreme Court, at which time the court decided that when the legislature said that any person could bring a claim for damages under the Environmental Protection Act, they didn't mean any person. They meant a special class of persons, and that special class of persons is those that have a property interest in the natural resource that's being threatened. Of course, many people believe that we all have a property interest in all of the natural resources of the state because they belong to all of us, but the Michigan Supreme Court doesn't agree.